On this video, we are going to analyze the question from the February 03 California bar exam, the crimes question. I will presume that you have read the question and given some thought to it, but just to make the video complete, I will read through the facts very quickly, then we will start our analysis. The facts read as follows. Don was a passenger in Vic's car. While driving in a desolated mountain area, Vic stopped and offered Don a hallucinogenic drug. Don refused, but Vic said if Don wished to stay in the car, he would have to join Vic in using the drug. Fearing that he would be abandoned in freezing temperatures many miles from the nearest town, Don ingested the drug. While under the influence of the drug, Don killed Vic, left the body outside the road, beside the road, and drove Vic's car to town. Later, he was arrested by the police officers who had discovered Vic's body. Now, Don has no recall of the events between the time he ingested the drug and his arrest. After Don was arraigned on a charge of first-degree murder, the police learned that West had witnessed the killing. Aware that Don had been arraigned and was scheduled for a preliminary hearing at the courthouse on that day, police officers took West to the courthouse for the express purpose of having him attempt to identify the killer from photographs of several suspects. As West walked into the courthouse with one of the officers, he encountered Don and his lawyer. Without any request by the officer, West told the officer he recognized Don as the killer. Don's attorney was advised of West's statement to the officer and of the circumstances under which it was made, and the officer's expected testimony at the trial that West had identified Don in this manner. New paragraph. Don moved to exclude evidence of the courthouse identification by West on grounds that the identification procedure violated Don's federal constitutional rights to counsel and to due process of law, and that the officer's testimony about the identification would be inadmissible hearsay. And the court denied the motion. New paragraph. At the trial, Don testified about the events preceding Vic's death and his total lack of recall of the killing. And you were asked two things. Number one, did the court err in denying Don's motion? Number two, and this number two is in two parts. If the jury believes Don's testimony, can it properly convict Don of A, first-degree murder, B, second-degree murder? Now, we are going to analyze these facts by, we're going to answer the question that the bar examiners have asked us. But we're not going to start with the question. We're going to start by going through the facts as they occurred, and we know what issues are likely to occur now because we've seen the entire problem. We know what it says, and we're going to jot down and talk about the issues as they occur, as the facts cause them to occur in our minds. Then we will organize our answer according to what we were asked to do. But in looking through there, we'll look at the events and see what issues of law are raised by the events which are described. So we begin at paragraph 1, which says, Don was a passenger in Vic's car. While driving in a desolated mountain area, Vic stopped and offered Don a hallucinogenic drug. Okay. Don refused. But Vic said if Don wished to stay in the car, he would have to join him in using the drug. And fearing that he would be abandoned in freezing temperatures many miles from the nearest town, Don ingested the drug. Now you see duress there, of course. And so you need to know the requirements for duress, and at some point in the analysis you're going to have to write about it. Duress requires a threat, and the threat must produce, the threat must be a threat of serious injury. Now, this serious injury historically has required that the threat be a threat of great bodily harm or death to the person. But the Model Penal Code simply doesn't say serious bodily harm anymore. It just says bodily harm. So apparently the policy is moving away from limiting the duress to great bodily harm or death. Now, we're talking about the duress required for serious crimes. So the duress, serious injury, great bodily harm or death, modernly only bodily harm. The threat must be of immediate bodily harm. Historically, it had to be imminent. However, again, modernly, the Model Penal Code and jurisdictions now are taking the position that the threat does not have to be so immediate, so long as it is a credible threat and enough so that a reasonable person would defend against it. The person is, the victim of the threat is obligated to use reasonable firmness, whatever that means. You don't have to be a hero. And finally, historically, the threat had to be directed towards the defendant at the trial. But modernly, it probably would not be required. So if the person said, if you don't do this serious crime, I will shoot your child. Well, that's probably good enough for duress. Historically, it was had to be directed at the person. Modernly, that is changing. So duress requires a threat that meets these requirements, which also produces fear. The person must become fearful because of the threat and have acted out of that fear. So the you can see the threat here, and you can see how the defendant, Don, is going to claim that there was duress. Now, one of the problems with this you need to be aware of is that duress is not a defense to an intentional killing of another person. Okay, even if the person says, if you don't kill that person, I'm going to kill you. Okay, that is not an acceptable defense to an intentional killing. Now, some jurisdictions have talked about reducing the penalty for a person who has to kill or act under those circumstances. But as it stands right now, the policy is, and you have to look a case-by-case basis, of course, but so far as the common law is concerned, duress is not a defense to an intentional killing. It doesn't have to be first degree. Intentional killing. Second degree is still an intentional killing. And so it's not a duress. But in our case, what you need to pay attention to here is that Don is not offering duress as a defense to the killing. Don is offering a duress as a defense to taking the drug. He's saying, I took the drug involuntarily. And so whatever happened to me thereafter was not the result of my drinking the booze or voluntarily taking the drug. As you know, voluntary intoxication is not a defense. But involuntary, as here, if he took the drug involuntary and he doesn't know, and it kept him from functioning normally, he can disclaim some liability for the effects of the drug. Now, so we understand about duress. Pardon me. We go to the second paragraph. Second paragraph says, while under the influence of the drug, Don killed Vic. Whoa, okay. So we know that Don did it. And he left the body beside the road. And he covered and drove to town in Vic's car. Later, he was arrested by the police officer who had discovered the body, and Don has no recall of the events between the time he ingested the drug and his arrest. So what issues come to mind as a result of that? And I'm sure you are thinking an insanity plea. because if you're involuntarily intoxicated, then you're treated as under the same rules as the rules of insanity. So it would be temporary insanity, but still insanity. So the question becomes then, can Don avoid liability for what he did during that period on the basis that he was insane? Well, let's look at the rules of insanity, and here they are. As you know, there are 4 versions of insanity that you need to know about, and you do need to know about all 4 of them. Let's talk about them. Insanity. First, the Macnaughton test. Now, this is the spelling that Macnaughton apparently was used in England. There are 4 acceptable spellings of Macnaughton, and the textbooks all mention this, and so this is taken out of one of the textbooks. The Macnaughton test for insanity has basically 2 requirements. One is the person did not know what they were doing. Either the person did not know what they were doing, or they did not know it was wrong. Now, there are some problems. There are some problems here. When you say the person did not know what they're doing, what you're really talking about now is essentially a disconnect where the person is your brain. We see something with our eyes and we act, and our brains tell us what we're doing and so forth. Well, if I'm doing something and as a result of my brain processing, I'm choking someone to death, but in my mind, I'm squeezing a lemon, well, that person has, they don't know what they're doing. And so one of the Macnaughton test says, if the person, because of a disease or defect of the mind, don't forget to put that in there, I didn't put that on the board. Because of a disease or defect of the mind, the person either does not know what they're doing, I just gave you an example of that, or the person did not know there was anything wrong with what they're doing. This is an or. They did not know what they're doing, or they did not know there was anything wrong with it. They thought what they were doing was perfectly all right. And this is the Macnaughton test. The problem with the Macnaughton test is because of a disease or defect of the mind. Don't forget that part just because I don't have it on the board. Because of the disease or defect of the mind, the person does not know what they're doing, or they did not know it was wrong. Well, what kind of wrong here do you mean? Do you mean they didn't know it was a law that's prohibited, that it was a conduct that's prohibited on the rules, and that there's a statute that prohibits it, and they didn't know the statute? No, we're not talking about that. And that's been it's gone back and forth among the academics for quite a while. And the standard now is that the person did not know. If you said they did not know it was morally wrong, well, that's been used too, but that sort of presents a problem because, whose morals are going to use? And so it's sort of come down to when the person did not know it was wrong, what do you mean by wrong? And the answer is that it would be disapproved of by the community. That and that's about as best as we can do with that. So this is the Macnaughton test. Now the problem with the Macnaughton test is that it requires such extreme standard, has such extreme standards that hardly anybody really meets those standards. I mean, how often is a person squeezing somebody's neck and they think they're squeezing a lemon? Okay, well that person is really so crazy that you don't encounter that sort of thing very much. And how often do you get a person who's doing something where it's killing somebody and they thought the community would approve of this? Okay, it's perfectly okay to do this. And people aren't usually that crazy. And when you set the standards that high, you end up with either the court system sort of manipulating the meanings of the words, or people who really are too crazy to be responsible for what they're doing are being held responsible anyway. So along comes some variations on it, naturally. One of the problems with the Macnaughton test is that it does not at all allow for the case where a person really cannot control their conduct. And there's plenty of psychological and psychiatric evidence now that there are circumstances where people simply, no matter how much they try, they are simply unable to control their conduct. And so the McNaughton test doesn't deal with that type of craziness. And so it should be included also. So they did know what they're doing, they did know it was wrong, and that's as far as that goes. And so here is a separate test called the irresistible impulse. The irresistible impulse test is the one that says the person was unable to control their conduct. Now, the problem with this is that it says irresistible impulse. And so from that you get the impression that the person has to have an impulse suddenly to do something, and try as they may, they can't stop themselves. But irresistible impulse does not require a sudden impulse. It can be planned. The event can be planned. It's just that if the person can't stop doing it, they can't stop the planning and stop themselves from moving ahead. So the impulse doesn't, the impulse part really doesn't mean what it seems to say. It really means, I mean, obviously this can't go on over a terribly long period of time, or you'd figure the person probably could resist. It wouldn't be believable. But in any event, it can be planned. It doesn't have to be just a sudden impulse. So irresistible impulse. Another test, so the McNaughton test, these extreme requirements of lack of cognitive ability, extreme requirements of lack of mental cognitive ability. Irresistible impulse, can't control what they're doing. The other problem with irresistible impulse is that the way it reads, you think the person had to be impulse, and as I said, it doesn't require that. But it says unable to control. Well, totally unable to control? And that's getting kind of extreme also. A lot of that may be stated in terms that are too severe. And the psychiatric community didn't think that was a realistic standard either. But nevertheless, we move on to the third standard, the Durham standard. Now, the Durham standard says product of, if the person's conduct, their crime, whether they did, was the product of a disease or defect of the mind. Product of the disease or defect. So they've got a disease or defect of the mind, and that's what caused them to do whatever it is they did. Now, the problem with that, and very few jurisdictions have adopted the Durham test. It's still around in a few jurisdictions, one or two, I think. But very few people have adopted, because the core problem with the Durham test is, what is a disease of the mind? The psychiatrists classify diseases of the mind for treatment purposes, because if it falls into one class, they treat them one way and so forth. But psychiatrists do not classify diseases of the mind. Normally, they don't classify diseases of the mind for the purpose of deciding how much social responsibility shall this person be held to, and what standard of social responsibility should you apply. So psychiatrists don't do that, and that's in the legal field. So what do you mean by disease of the mind? And so that got to be so uncertain that there are hardly any jurisdictions, that's why it's only one or two jurisdictions, that follow the Durham test. Then finally comes the Model Penal Code, which does a pretty good job, really, of kind of combining all of these. All of them start out by saying, as a result of a disease or defect of the mind. McNaughton requires that. Irresistible impulse, as a result of a disease or defect of the mind, the person is unable. The Durham, product of the disease or defect, the conduct was. And so here, the Model Penal Code, and you must include this in your analysis, as a result of a disease or defect of the mind. That's the first part. The person, instead of saying the person cannot appreciate the let me read it to you exactly. Sorry, I plan to use just the notes on the board, but I want you to, I suddenly changed my mind about that. I want you to see exactly what it says. And here it comes. I'll have it for you in just 1 second. Okay. Okay, the model penal code says sorry. Here we are, I think. Here, Model Penal Code, Section 4.01, Sub 1. It provides, quote, a person is not responsible for criminal conduct if, at the time of such conduct, as a result of a mental disease or defect, he lacks substantial capacity to appreciate. That's why I wanted to read, because the word cannot went too far. I wasn't thinking when I wrote this. So, as a result, I'll keep reading here so we got it just right. As a result of a mental disease or defect, that's right here, he lacks substantial capacity. Lacks substantial capacity. Okay. I put here substantially lacks capacity, but it says lacks substantial capacity. Okay. Lacks substantial capacity to appreciate the criminality or wrongfulness of his conduct, or to conform to the requirements of the law. Let me read you that again. A person is not, it's because what's on the board here. I'm going to change the board just so that it will reflect more exactly what the MPC says, because that's the one that you want to be sure that you know. So the Model Penal Code says, a person is not responsible for his criminal conduct if at the time of such conduct, as a result of a mental disease or defect. So the first part is result of mental disease or defect. Result of a mental disease or defect, the person lacks substantial capacity to appreciate. Lacks substantial capacity lacks substantial capacity to appreciate the criminality and some jurisdictions use the word wrongfulness here. The Model Penal Code gives you an option to adopt either criminality or wrongfulness because of that long-standing problem that I told you about. To conform his conduct to the requirements of the law, lacks substantial capacity to either appreciate this or say, I really should do it even differently. I'm sorry. I really want you to see this. See this the way you can best remember it for the exam. Lacks substantial capacity to. Okay. It reads all in one sentence, but this is the easier way to remember it. Lacks substantial capacity to appreciate and here you appreciate either criminality or wrongfulness or to conform conduct to the law. Okay, this is the easiest way to remember it. As a result of a mental disease or defect, the person lacks substantial capacity to do this or that, either one, this or that. So you see how the model penal code has combined, when instead of saying McNaughton, under the McNaughton, a person didn't know what they were doing was wrong, or didn't know what they were doing or that it was wrong, it says they lack substantial capacity, that's softening it, to appreciate the wrongfulness of it. Not that they didn't know it, so they softened everything. And substantial capacity to conform, that softens this one. And so this is the standard. Now you can see easily, of course, how you could apply that standard to our person, Don. Don, what will Don say? Don will say, at the time, whatever happened, that was like, in my mind, it's like, I don't remember what happened from the time I took the drug until I was arrested. And that part of my mind was functioning differently. And I didn't willfully cause it. It was functioning differently, and my normal mind really didn't know what I was doing. So you can see how this person might qualify under McNaughton. Even if they didn't qualify under McNaughton, you could argue Durham, product of a disease or defect. Well, you could say this is a product of a drugged mind, involuntary drug. And finally, under the model penal code, as a result of the involuntary drug, instead of the mental disease or defect, or you can say the use of the drug caused a defect of the mind, that person lacked substantial capacity to do these things. So you can certainly make an argument that he was insane under those standards. Now, moving on with the rest of the problem so we can get through this, in the third paragraph it says, after Don was arraigned on a charge of first-degree murder, the police learned that West had witnessed the killing, and aware that Don had been arraigned and was scheduled for a preliminary hearing, so the cops knew that Don had been arraigned. By the way, the fact that Don has been arraigned is important because there's a identification process is about to happen, and the right to have a lawyer present at the identification, at the lineup, not all identifications, not photo identifications, for example, but the right to have a lawyer present at a lineup, that type of an identification is a part of this, is in the Sixth Amendment, and that you don't have a Sixth Amendment right to the assistance of a lawyer until judicial processes start. And the first judicial process starts when you first go to court, and the state says, we charge this person with a so-and-so crime. Up until that time, cops may have done lots of things, but there's no judicial process until you go to court the first time. Well, if the arraignment occurs after you go to court the first time, then the arraignment is the first time, but if the lineup occurs, after you go to court the first time, then when the lineup occurs, that's considered a critical stage of the judicial proceedings. And so you have a right to counsel at the lineup if the lineup happens after the arraignment. If the lineup happens before the arraignment, you do not have a Sixth Amendment right to lawyer at the lineup, and you don't have a fifth one under Miranda either. Continuing then, says, aware that Don had been arraigned. So the police knew that Don had been arraigned. So Don has this right we just talked about. And that Don was scheduled for preliminary hearing at the courthouse on that same day. So they knew he'd be walking around there that day. The police officers took West to the courthouse for the express purpose of having him attempt to identify the killer from photographs of several suspects. And as West walked into the courthouse with one of the officers, he encountered Don and his lawyer. And without any request by the officer, West told the officer he recognized Don as the killer. And Don's lawyer told, the police told West's lawyer told Don's lawyer that all this has happened. So the question, obviously, is this a lawful identification? Now, Don has claimed, in fact, in the very next paragraph, Don claims that this identification was unlawful. And he has three bases. He says the identification violated his right to counsel, his right to due process, and that if you allow the officer to testify to what West said, that will be hearsay and not admissible. So let's start here, right to counsel. Now, once again, West is simply walking in the courthouse corridors and sees Don and his lawyer in the corridors, and Don said to the police that West, the witness, West, said to the police, that's the killer. Now, is this an unlawful identification? Well, let's talk about the basic rules here. The basic requirement for identification is that it is not unnecessarily suggestive. And the full statement comes out of a case called Neal versus what's that case? Something I can't think of the rest of the case now. But in any case, what the court said in that case, and several other cases, what the court said is that an identification violates due process if the identification is so impermissibly suggestive, some say unnecessarily suggestive, it's been said in some other cases, so unnecessarily suggestive or so impermissibly suggestive as to create a real and substantial likelihood of irreparable misidentification. Okay. So impermissibly suggestive as to create a real and substantial likelihood of irreparable misidentification. Now, you know what irreparable identification is. Once a person has made a mistake and identified someone as the person who did it, they just keep on identifying from then on. It is not an original identification anymore. So the misidentification becomes irreparable. So that's how you decide whether or not an identification violates due process. Now, you don't always have to have a lineup in order to not violate due process. Obviously, having a lineup is one way to deal with the problem, a fair lineup, so it's not so unduly suggestive. But another way, I mean, suppose you ran out of your house one morning, you were standing on the porch of your house, and you saw your neighbor that you've been living next door to for 30 years run out of the house with a smoking gun and get in the car and drive away. And then you were asked later by the police who left the house. Well, you don't need a lineup. Okay, you've been seeing this person every day for 30 years. And so you see the point that there are some situations where you really don't need a lineup. And so where do you draw that line? How do you decide whether or not a lineup really is needed? And the courts looked like as a one-on-one show. There's one case where in Neal versus Beer, is a case I was trying to think of a minute ago. It was a case where a woman identified a rape suspect in a photo. But what had happened is that she had gotten a real good look at the person in bright kitchen room light. When she later tried to identify, she went to the police photographs, went through lots and lots and lots of photographs and couldn't find the person. She came back later and went through more photographs and said, no, that's not him. Finally, 6 months later, the police called her and said, gee, we'd like you to come and look at another photograph. And so she went down there and they showed her one single photograph. And she says, that's him. That's absolutely him. I would know him any place in the world. That's him. And so at the trial, of course, defense counsel said that was an unduly suggestive identification because only one photograph was held. The court came out of the rule that came out of that case is that the factors you look to try to decide whether or not the identification was fair are factors such as, number one, how much opportunity did the victim have to observe the defendant at the time of the crime? Number two, how long ago was it when this happened? How much time has passed since the crime and the identification? Number three, how much attention was the witness paying to the defendant at the time? The defendant might have just been running through the park and you just kind of got a little glance at him. On the other hand, if you're a direct victim, you look in the person right in the face in the kitchen light, well, of course, you got a good look at it. So how much attention was paid to the victim, to the defendant at the time of the crime? Any descriptions that were given at the time. The more complete the description is, then that's another factor. And the final factor is the level of certainty. How definite is the witness that this is the person? So you don't always have to have a lineup. And so here's a case where we don't have a lineup. We don't have a lineup, but we don't really have those factors either. We don't know how much attention Wes paid at the time. We know it wasn't very long ago. It was only a few days ago, a week or so ago. But we don't know how much attention Wes paid, how good a look Wes, how much opportunity he had to view the person at the time. We don't have any descriptions of the person. And so we don't have a lot of those factors. And so what do you, but are they necessary? Because in this case, the argument you would make is that this was really not a police manufactured lineup, that this person was just out in the public. And while Don was out in the public with his lawyer, apparently walking in the hallways of the courthouse, apparently not in shackles or anything, and so there's no reason to pick that person out. And under these sort of public settings, Wes says that's the person who killed. And so you'd say there is a lineup. A lineup is a fair display of people from which the victim or someone, the witness, is supposed to pick out who did it. Well, this was a fair display of people. It's scattered all over the courthouse. And so the lawyer has a right to be present at the lineups so that you can see how it's conducted, and that there was no manipulation of the witness by the police and that sort of thing. So the lawyer would be present at the lineup if the lineup occurred after the arraignment. But in this case, the lawyer was present. And the lawyer was present and could see that there didn't seem to be anything that would cause Wes to pick out Don as a person in the hallway of the courthouse who did it. And so, given all those factors, do we have a violation of right to counsel? Well, what you would say is that there is a right, that because Don has been arraigned, that he does have a right to counsel, a Sixth Amendment right to counsel. The right to this, you point out the Sixth Amendment's applied to the states, to the Due Process Clause of the 14th Amendment, that it begins with the first court hearing, and that it applies to all critical stages of the proceedings, and an identification, a lineup identification is a critical stage. But that in this case, this was not, the lawyer was actually there, but it wasn't even staged by the police, unless you think it was. So his Sixth Amendment right to counsel was not violated because if you want to view the halls of the courthouse as a lineup, then it was a fair lineup. Or you can just say it was out in public and there was no lineup, and therefore these kinds of accidental identifications, the rules do not apply. Finally, counsel needs to be effective counsel. Now, in our case, we don't have the case of a lawyer who was ineffective in representing the client at the trial. But since we're talking about Sixth Amendment right, this is a good chance to expand further than you need to for this question to get a good handle on the concept of effective counsel. First of all, let me point out that the Sixth Amendment says that the defendant has a right to the assistance of counsel. And that means that the defendant can always defend themselves in a proper person, in pro se, if they want to. And in the old days, that's what people did mostly. So the defendant always has a right to defend themselves. The only thing the judge has to determine, not that this person has a law degree or is a college graduate or any of that, it's just that the person is an intelligent and knowing waiver of his right to counsel. And the person understands that, and the judge generally tries to explain to the person that a trial is not a simple process where people just kind of stand up and tell their story, that there are complicated games of rules of procedure. But after the judge explains that, if the person still wants to represent themselves, you have to let them do it unless they're just outright crazy. Now, so you have a right to represent yourself and your right to assistance of counsel at all critical stages of the proceeding, and it begins with the first right to first hearing. Effective counsel. There are several ways in which a person might, the right to effective counsel may be brought in. And that is, there are some circumstances where the state itself interferes in such a way that the person doesn't get effective counsel. And the other is where something that the lawyer does, trying to represent multiple clients in the same crime, or the lawyer is just ineffective, doesn't know the game very well. So there are things the state may do and things the attorney may do resulting in ineffective counsel. I have some examples here on the board. This is highly abbreviated, so I would wouldn't forget any of these. The first one is a case where this was or was in Tennessee or someplace, not sure where this was. But anyway, the defendant in a crime had been examined by the prosecution, or examined by somebody, and examined by the prosecution, probably on cross-examination. But in any event, the judge said to the defense lawyer, you cannot talk to your client between now and when we get back to trial after lunch. There's actually a little longer break than that, it's about a 6-hour break. It says you cannot talk to your client in between when the DA interrogated them on the stand and when they're going to come back from this break. And the court says, no, you can't stop the lawyer from talking to your client during the break. And so that was ineffective counsel caused by the state, the court's ruling. There was another case where where there was a rule that said if it's a trial before a judge instead of a trial before a jury, that the judge can waive closing arguments. Just say, I don't want to hear any closing arguments. And the court found that to not allow a person to make a closing argument, even if it's before the judge, that creates ineffective assistance of counsel. Another way that the state can create ineffective assistance of counsel is where there was a case in, this was a Tennessee case. The Tennessee case where there was the law was that if the defendant is going to testify, they've got to testify first. You can't wait for all the witnesses to testify, then let the defendant testify. And the court said that's ineffective assistance of counsel. One other case where the state had an undercover police officer who had worked with the person who was charged with the crime, and both parties were arrested in order to keep the cover of the undercover police officer. Well, the true defendant in the crime asked the undercover police cop, who was his jail buddy, to come with me to the hearing with my lawyer. And so you end up with the state right in the middle of this person's defense, listening to everything and maybe even participating. And so the defense, of course, claimed foul play because the undercover cop testified at the trial, to the surprise of the defendant. And of course, defense counsel said, hey, you've invaded the attorney-client privilege, invaded our privacy. This testimony should be excluded. And so what happened in that case is the court allowed the undercover police officer to testify, but did not testify to anything that up until the time of the arrest, and not anything that happened later when they went to see the lawyer and so forth. So they did let him testify. Finally, you can get ineffective assistance of counsel by an attorney having a conflict, more than one defendant from the same crime, and finally just incompetent counsel. And here the rule is you must have reasonably effective assistance of counsel. In deciding whether or not the attorney was incompetent, reasonably effective assistance of counsel is the standard here. Okay, now that gets us, so he made 3 motions. One of his motions was the right to counsel. We've talked about that. Next is due process. Well, we've already talked about that. Due process is requires that says that the identification violates due process if it is so unduly suggestive as to create a real and substantial likelihood of irreparable misidentification. And the final claim was that if you allow the officer to testify to what West said, that it would be inadmissible hearsay. Well, the rule for that is that the Federal Rules of Evidence at 801 D1C, as you can see here on the board. And what that rule says is that if a person makes a prior identification of someone, let's say a witness goes to a lineup, and at the lineup they identify number 3 as the person who did it. And now comes the trial. And at the trial, the witness is asked, and who is the person who did it? Can you identify them in the room? And the person on the stand says, no, I can't identify the person. Maybe the witness has now shaved and changed his hair and changed his clothes and dyed his hair or whatever. And the person says, no, I cannot identify the person in the room just now. Right now. But this person did identify them at the lineup. And so the question becomes, are you going to let the lineup identification be admitted? And 801 D1C says, yes, the previous identification can be admitted if the witness is on the stand now and available for cross-examination regarding that previous identification. The problem here is that it is Wes who made the previous identification. And Wes told the police officer, and the police officer is testifying. Well, if Wes were on the stand testifying, Wes could say, even if I can't identify him now, can say I identified him, this person earlier. But we don't have this situation. This is just the police officers on the stand. So the person who made the earlier identification is not on the stand available for cross-examination. Therefore, this does not apply. Okay, so that brings us then to the last of this problem, and that is, can Don be convicted of first or second degree murder? And that part's pretty easy. First degree murder. First degree murder is common law murder. Common law murder is also second degree murder. Common law murder and second degree murder are the same thing. First degree murder is common law murder under aggravating circumstances. Now this word aggravating circumstances is a word that I made up because I don't know how else to put it. But this whole list of things like premeditated, deliberate, willful, lying in wait, poison, torture, bomb, killing of police officers, felony, killing a person during the commission of an inherently dangerous felony, killing a child during the commission of a sex act, and all that stuff that will get you first degree murder, that whole list, I'm calling them something, so I'm calling them aggravating circumstances. This is not the same as special circumstances, which will elevate you from first degree to capital, where the defendant gets executed. But this is just enough to elevate what would have been second degree up to first degree. Well, can Dan be convicted of first degree murder? Well, that means to do that, you got to convict him of common law, of the common law murder, and the aggravating circumstances. So we start with the common law murder. Can Don be convicted of common law murder? Definition: common law murder is homicide with malice, without excuse or justification or mitigation. Now, as to the homicide, we have that because the bar examiners tell us that Don killed Vic. Did Don have malice? Don doesn't know what happened, so we don't know if any of these things happened. That's a problem, but we're not going to try to solve it because we don't need to. Without excuse, well, Don has two defenses. You can't prove the malice because they don't have any facts, and the burden of proof is on the state. Person might have slipped and fall, except the facts do say Don killed Vic, but the state, I don't know how they're going to prove it. I don't know how they'll prove the malice. Next, without excuse, justification, or mitigation, the two excuses are infancy and insanity. And so here's where you use the four versions of insanity that we talked about over here under insanity. So you write in your four versions of insanity and say that, and make you apply the facts and say that he has the excuse of temporary insanity. Justification, which are the privilege and public authority. We don't have any facts to that effect. And mitigation, if it was mitigated, it'd be mitigated down to one of the manslaughters, voluntary or involuntary manslaughter. It could be mitigated to voluntary manslaughter, or it might be involuntary manslaughter if you can't prove the malice. But you were not asked about involuntary manslaughter, so you don't need to go off and talk about that. The only thing you ask is, can Don be convicted of first-degree murder or second-degree murder? This is second-degree murder here, and certainly if he cannot be convicted of second-degree murder, he cannot be convicted of first. Can he be convicted of second-degree murder? No. Insanity. Finally, even if he was convicted of second-degree murder, which we think is impossible, that you could not prove aggravating circumstances such as premeditation, deliberate lying in wait, poison, bomb, torture, killing the police officers, killing of a child doing sex acts, felony murder rule. You couldn't prove any of the aggravating circumstances that would elevate it to first degree. So the answer to the problem then ultimately is that Don could not be convicted of even second-degree murder because of the insanity defense, and also because the state cannot prove the malice. They have to prove the malice beyond a reasonable doubt. They don't know what happened, so they can't prove any malice. Well, they have Wes. If Wes saw it happen, maybe they could prove the malice by Wes's testimony if they put Wes on, but Wes isn't even testifying so far. So without Wes's testimony, they can't even prove the malice. If they can't prove, and plus the insanity defense. So the two defenses to second-degree murder are they cannot prove the malice and the insanity defense. Clearly, if you cannot convict them of second-degree murder, you couldn't convict them of first. But even if you could convict them of second-degree murder, the additional factors you need to elevate that to first, none of them are present. And that is the end of the analysis of this problem.